Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. Thanks for watching. First on the docket, Chad Daybell has a hearing on Monday. Can you hardly wait? Second, Breonna Taylor case update. Why the police probably won't be charged in her death. Third, prosecutors not charging the officer in the Ferguson, Missouri death of Michael Brown. Wonder what took so long. Fourth, Gelane Maxwell documents have been released. A Florida couple arrested for breaking quarantine. And yes, our dumb criminal contestant of the day and a recap of our dumb criminal contestants of the week so you can choose the winner. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch. Thanks for watching. If you haven't done so already, we'd ask that you hit that subscribe button, hit that little bell so that you receive notifications of when we put up new content or we go live. And as always, leave us a comment below. We do read them. First on the docket, Chad Daybell. That's right, you know, the husband of Lori Vallow. He has a preliminary hearing coming up on August 3rd. It will be televised. Now, a couple of news agencies apparently don't watch Crime Talk, otherwise they would know that the court had ordered that one pool reporter will be allowed to televise the proceedings. Yet, a lot of news organizations continue to file requests asking that they be allowed to record and video and stream via the internet the proceedings. And they're promptly denied because the court has stated there'll be only one pool reporter and they will share that information with everyone. Just another reason why everyone should watch Crime Talk. Now, the preliminary hearing is going to be interesting. Yes, it will be a regurgitation of the affidavit for the arrest warrant, which will establish probable cause. Because remember, the case is not going to go away because the judge has already found that there's probable cause. Hence the reason both Vallow and Daybell are under arrest. Where I think the good watching will come in is the attorneys, okay? The attorneys for the defense. In this particular case, it's Mr. Pryor. He's an experienced attorney. He's been around the block a little bit. Let's see what questions he asks. A preliminary hearing, in my humble opinion, is handled much differently than it is at a trial. At a trial, it's the classic case if you don't ask the questions that you don't know the answer to. But sometimes on the defense side, you simply want to say, what evidence do you have against my client? Okay, you give them every chance to lay it all out. You sure there's not anything else? That's it. And then you've basically locked them in for future court proceedings. We'll see if Chad Daybell's attorney will do that or whether he will try and think he's going to get this case dismissed. It never works, the preliminary hearing. Literally, I can count on one hand the cases where charges or the entire case has been thrown out of the preliminary hearing. It just doesn't happen. But we'll see if this turns into be a legitimate court hearing or if this will turn into a circus. I believe the real circus will begin the following week, August 10th, when Lori Vallow's preliminary hearing begins. Her attorney, Mr. Means, has been somewhat less than impressive, and I'm not really sure he knows what the hell he's doing. We'll have to wait and see. I'm a little surprised that the prosecutor has not moved to consolidate these preliminary hearings into one hearing. The more opportunities that a witness gets on the stand under oath, subject to cross-examination, is more likely to say something that they misstate or state out of context, which can be twisted, misconstrued for the benefit of the defendant. The defense, if they're going to make any strides in this particular case, is let these detectives talk, let these special agents talk, and maybe over-exaggerate or overstate something that later they can prove, the defense can prove, that isn't in fact true. We'll definitely have to wait and see if they have something more than the actual cell phone records information and if they have concluded as to who actually committed the murders of JJ and Tylee. It's going to be good watching. Hope you'll join us. Next on the docket, the Breonna Taylor case. Why the police probably won't be charged in her death as it relates to the March 13th incident where the police were executing a search warrant because they had information which they believed was accurate from the United States Postal Service, which the United States Postal Service later said that was not accurate information, that drugs had been delivered to Breonna Taylor's address. When the police executed a no-knock warrant, even though they said they knocked, Kenneth Walker, believing that a home invasion was taking place, fired one shot, striking an officer. The officers then returned fire, whereupon Breonna Taylor was hit and ultimately died. Well, 10 million people have signed a petition at change.org demanding that the officers be charged in relationship to the death of Breonna Taylor. A lot of celebrities, including LeBron James and Beyonce, have joined the outcry for justice for Breonna. Now, a national newspaper conducted interviews with 7 experienced Louisville defense lawyers who are not involved in the case in any way related to Breonna Taylor, and they all had an average of some 37 years of practice, and every single one of them stated that the officers will not be charged because they had a legal right to defend themselves once the boyfriend opened fire at them. 3 of the 7 defense attorneys that this national newspaper interviewed were black. One of the attorneys was the former president of the Louisville, Kentucky NAACP chapter, had spent much of his 40-year career fighting the police. He concluded that they just don't see the case being filed. All of the attorneys stated that once the boyfriend, Kenneth Walker, opened fire, that the police had a right to shoot. Now, obviously, counsel for the estate and family of Breonna Taylor believed that the fire and the number of rounds by the police was excessive and was completely unnecessary, which is why they are asking for the police officers to be charged. Now, the 3 police officers, Sergeant Jonathan Mattingly, Officer Miles Cosgrove, and now ex-officer Brett Hankinson, still await any outcome as it relates to this particular matter. Many of the attorneys believe that the only way these officers would be charged with something is if they knew that the information obtained from the Postal Service was false, and they knew it was false when they filed the information in the affidavit to obtain the search warrant. Several attorneys noted that it's part of police training that if somebody fires at you in a house, that you are going to return fire. Many of the attorneys also expressed complete empathy with people like LeBron James demanding justice. And although terrible things have in fact taken place, the law in this particular case states that these officers probably will not face charges. The mere fact that this incident took place on March 13th and nothing has happened thus far would make me believe that no charges will be forthcoming. I truly believe that the law should apply to everyone equally, and there's good arguments to be made that the officers were reckless in their entry of the home and the number of rounds that they returned back at Kenneth Walker. However, they also had a right defense of themselves if someone had fired a shot at them. But as you'll see in our next story, the longer things drag out, the less likely things will ever happen. Well, just like in the Breonna Taylor case, sometimes investigations take a long time. Well, do you remember the case of Michael Brown, little case in Ferguson, Missouri? You probably did. As you may recall, there was a lot of upset people regarding that particular case, and ultimately several organizations have investigated the matter, and ultimately no charges have been filed. And now, officially, 6 years later, the officer who shot Michael Brown, now former officer Darren Wilson, will not be criminally charged by the St. Louis County Prosecutor's Office, as they stated on Thursday. In a press conference, Wesley Bell, who's now the prosecutor in St. Louis, stated it is one of the most difficult things he's had to do as an elected official, announcing that the findings of an independent 5-month review and that no charges will in fact be filed. Mr. Bell, who was elected St. Louis County's first black prosecutor in 2018, said that the investigation doesn't exonerate Wilson. However, he stated that after examining thousands of pages of witness statements, forensic reports, and other evidence, Bell stated that he was unable to prove beyond a reasonable doubt that Darren Wilson committed murder or manslaughter under Missouri law when he shot and killed Brown. We've talked about this many times on Crime Talk. There's lots of things in the world and injustices that take place, but the law is there for a particular reason, and it is to remove the emotion from the particular battle or incident that's taking place at the time. And prosecutors have an ethical obligation only to bring charges on cases and against defendants when they believe that they can prove each and every element of the offense charged beyond a reasonable doubt. And they have to be able to prove that as of this particular time of filing of charges. Here, after 6 years, the prosecutors have tried, and the evidence has turned around each and every time that there's evidence that Brown attacked then Officer Darren Wilson, which would have justified his actions at the time, regardless of how many people don't feel it was appropriate or believe that it was in fact an injustice. The previous prosecutor turned the matter over to a grand jury, and that grand jury declined to indict Wilson back in November of 2014. The United States Department of Justice also declined to prosecute the officer back in 2015. Ultimately, Mr. Brown's family received a $1.5 million settlement after they sued the city of Ferguson for the death of Michael Brown. This case now appears to be closed. Next on the docket, Gelane Maxwell documents are being released. We briefly touched on this matter yesterday related to Gelane Maxwell, where the judge ordered that certain documents may be released from a civil case dating back to 2015 and 2016, which ultimately Miss Maxwell settled. The fight really became regarding the release and the privacy interests of Gelane Maxwell, which the court determined was rather insignificant in light of the more serious allegations that she has before her. And then there were issues regarding the prosecutors wanting to be able to name all the people who are making allegations against Miss Maxwell. The judge stated, no, you can't do that. Although some of the victims have come forward appearing at detention hearings for Miss Maxwell, the judge stated that these complaining witnesses still have an expectation of privacy and that privacy interest must in fact be safeguarded. The prosecution argued, and probably correctly, that by releasing the names that there would be public outcry or threats against the women who have in fact made these allegations, really kind of an attempt to strong-arm them into not testifying. The intent being, obviously, if they were harassed or threatened, that they would no longer cooperate with the government. Now, the documents that have been released thus far indicate that Miss Maxwell and Mr. Jeffrey Epstein communicated back in 2015 when things started getting ugly again as it related to Mr. Epstein. In emails, Mr. Epstein wrote that she should make statements denying that she's done nothing wrong, and told her, in fact, she had done nothing wrong, and start acting like it and going out in public and holding her head high and not cowering as though she was a criminal. Documents also released indicate that there were lots of, for lack of a better term, orgies going on at the Virgin Island residence of Epstein. Now, these stories have been brought out in the past, but these come out in a little more greater detail. Some of the names that have come out are former governor of New Mexico, Bill Richardson. There are allegations against Prince Andrew. There's also people that identify Bill Clinton and Al Gore on the Lolita Express. Now, all of these individuals have denied any wrongdoing or any sexual relations with anyone, particularly anyone under the age of consent. We will give everyone the presumption of innocence and understand these are just simply allegations that have come forth in the documents that have been released. You all will have to be the judge as to whom you believe participated or was just simply in the wrong place at the wrong time. Somehow I had a feeling, though, that most of you will agree that nobody got on Mr. Epstein's Lolita Express unless they were meant to be there. And as some of the young ladies, girls, have stated, that Epstein bragged about having something on everyone. Could that something be videotapes of them engaging in lewd and lascivious sexual acts with young girls? Perhaps. We'll wait and see. We're still waiting to see if Miss Maxwell will have an opportunity to proffer with the government or if she'll reach a plea agreement. And as always, today is day 29 of the suicided watch for Gelane Maxwell. The count continues. Ladies and gentlemen, if that last story isn't enough to tell you, you really need to know with whom you're dealing with. Now, are you ever going to actually know everything? You probably may not. But if you go to CrimeTalkSearch.com and sign up for a background subscription service, you're going to know a lot more. If you go there and you subscribe, you can do as many background searches as you desire, and they're all done anonymously. No one will ever know that you did them unless you share the report with them. So think about it. You see a phone number on, say, your boyfriend's phone, your husband's phone. Seems a little weird. Guess what? You can type that information in, find out who it belongs to. Email addresses. You can find out that information as well. You can find out information regarding criminal history, property records, civil judgments, as well as marital records. We've had more people email us and thank us about signing up. It saved them from getting into a bad relationship or a bad business venture. We use it in our law firm every day. You'll be happy you did. Go to CrimeTalkSearch.com. You won't be disappointed. Next on the docket, a Florida couple has been arrested for, get this, breaking quarantine. Jose Antonio Freire Interian was walking his dog near his Key West home when a neighbor began recording him on her cell phone. Hours later, the police arrived, arresting him and his wife and ultimately taking them to county jail. The charges? Yep. Violation of quarantine after testing positive for COVID-19. Now, the Florida Keys closed themselves off to visitors and the 6,600 residents that were in fact there. Now, there's been a huge national debate, obviously, about staying home, wearing masks, you name it. We've talked about all the stories. It's a huge national debate. We've heard stories of the Kentucky woman infected with the virus was arrested while shopping at the grocery store. There was a case that a coronavirus patient was chased down and arrested in Nashville after being placed under quarantine by public health officials. In Hawaii last month, 21 travelers were arrested for violating the state's mandatory quarantine law, where they had to reside for 14 days in quarantine. Of those 21 arrested, none actually tested positive for the COVID-19. State officials allege that Freire Interian and his wife, Johanna Anahe Gonzalez, learned that they were infected with the virus on July 15th after learning their results a few days earlier. On July 20th, the court issued a mandatory order for quarantine against the couple. Both Freire Interian and Gonzalez were shocked by the arrest and subsequently bonded out. It does seem a little unusual that you want to arrest somebody and take them to the jail where in fact they could be exposed to and spread the disease to even more individuals. The last time we saw enforcement of something like this was when states passed a lot of laws stating that people could be charged with potentially murder if, for example, they knew that they were infected with AIDS and they did not have protected sex. I hope we're not getting to that point, ladies and gentlemen, but it appears as though a lot of people are overreacting, and who knows, maybe they're right. Only time will tell, but it doesn't appear that possibly the best use of governmental resources, limited governmental resources, to arrest people for walking their dog. Unless the police department is going to come over and walk the dog for the person that's got home quarantine, I'm not sure how they think that's going to hold up in court. Next on the docket, our dumb criminal contestant of the day. Ladies and gentlemen, meet Stephen Lee Donovan. Yes, look at this fine young man. Well, Mr. Donovan is a 22-year-old pizza delivery guy, and he was allegedly pleasuring himself outside of a convenience store in his 1996 Honda Civic in the parking lot. Although Mr. Donovan will ultimately state to the police later that he didn't think it was illegal to pleasure himself in his own car, the mistake he made was that if somebody sees you pleasuring yourself in your own car, it can in fact be a crime. And in this particular case, Mr. Donovan was spotted by an off-duty police officer who took down the license plates and called in the car for the unknown pleasurer as such. When the police arrived, they were unable to clearly determine that Mr. Donovan was the person allegedly involved, because why? He had a mask, and why is that of significance? Because identification is ultimately the issue in a criminal trial. But don't fret. Once again, someone that should be watching Crime Talk and learning about one's constitutional rights and things to do. Obviously, Mr. Donovan is not. He spoke to the police, and although didn't say that he was in fact pleasuring himself, he did in fact corroborate he was at the convenience store because he wanted to get a drink because he was thirsty. Now, unfortunately for Mr. Donovan, he was also arrested in front of his girlfriend, who was at the residence at the time, when she spoke with him in the back of the police car, which was monitored by a dash cam and fully recorded. Mr. Donovan apologized to his girlfriend and ultimately stated he didn't think that it was illegal to pleasure himself with pornography in his own car. Mr. Donovan, you are our dumb criminal contestant of the day. Now, you have some stiff competition, Mr. Donovan, to beat today on our dumb criminal contestant. Yesterday, you had our flight attendant who beat up her boyfriend / live-in husband, who was found having a sexual relationship with another woman. Then we had the Massachusetts couple that was out walking their dog naked, which resulted in assault on a police officer charge. The day before, we had David Hines, who stole PPP money from banks by providing false information and spent it on living large, including a $330,000 Lamborghini Huracan. And yes, let's not forget Dakota Dorenzo, who fought her dad and injured him by grabbing his groin because she wanted to sample some of his medical marijuana while she was home from school, because she considered herself quite the connoisseur. Ladies and gentlemen, leave me a comment below. Who do you think is the dumb criminal contestant of the week? And also, leave me a comment below as it relates to what do you expect is going to happen at the preliminary hearing on Monday for Chad Daybell? Do you think it's justice or an injustice if the officers are not charged in the Breonna Taylor case? And why do you think it took 6 years to formally say we're not going to charge the officer in the Michael Brown incident? Is that just the common tactic of delay, and hope it goes away? Let me know. Have a great weekend. We'll talk to you next time on Crime Talk.